Welcome, sir. Welcome to our event.
Yes, ma'am. Thank you.
Okay. Over to Jens.
Okay, good morning to everybody present here. Today is your opportunity to build the tomorrow you want. A quote from Ken Poirot. Let me take this moment to extend a very warm greeting to everybody here for the workshop on intellectual property rights and IP management for startup on the behalf of the Jeppiaar College of Arts and Science. I would like to call Mr. Gokul from First BCom General to deliver the welcome address.
Thank you, Aditya. A delightful evening to one and all present here. A quote from Jim: success will not come overday or overnight, but it will definitely come if you will hard work every day and every night. It's my pleasure to extend a cheerful welcome to all. I would like to welcome our expert chairperson, Dr. Mrs. Regina Jayamurli ma'am, and our director, Mr. Murli sir, and our honorable chief guest, Advocate Mr. Pushkar Ravishankar sir, IPR constant and lawyer, and our de- Delightful principal ma'am, Dr. Mrs. Lavanya L, and HODs of all department and EDC faculty members and teaching and non-teaching staff. I welcome our conveners, our organizing committee members, and our students coordinator. And and finally, a cheerful welcome to our students. Welcome all.
Thank you, Gokul. Now I would like to call our principal, Dr. L. Lavanya, to facilitate the gathering.
Thank you, Aditya. A very good evening to one and all present here. I start this felicitation welcoming our chief guest. Welcome the advocate, Mr. Pushkar Ravishankar. Welcome, sir. And thank you for accepting this invitation at a short notice. I congratulate Dr. Jayaselvi ma'am and Abhirami ma'am for taking this forward and being committed to the program of as per the EDC and IIC norms. It's helping to see Aditya and other students coordinating and stepping in for programs like this. It is definitely a very good exposure for all of you, those who are attending the program as well. And talking about the intellectual property rights and IP management for startup, like all this young, budding entrepreneurs over here, they all have ideas and startup ideas. And last week, like a couple of days back, we had a session on how to build their model canvas and all that. But it's also important that nobody takes away the idea from you, right? So it is important, like which category of IPR it falls in, and how to document it, how to get it authorized, how whom to approach, and all this matters a lot. As in, future entrepreneurs, you should know what needs to be taken up in those regards. So the legal perspective of it, the chief guest today will be sharing. So we are waiting to hear from you, sir. And I thank the management for giving us approvals for conducting programs like this. And I also extend my thankfulness to all the organizing committee members, students, student coordinators who have been always, in the forefront to keep this IIC and EDC active and getting the IPR cell active as well. Okay, so over to you, Aditya. Thank you so much.
Thank you, ma'am. Now I would like to call Swati from First BCom A&F to introduce our chief guest. Swati?
Good evening. Yeah, I'm here. Good evening to one and all.
Hey,
It's my great pleasure to welcome our chief guest, Mr. Pushkar Ravishankar, advocate experience in the area of civil litigation company, law banking, and real estate, intellectual property rights, and so on. He completes graduate of BA LLB from MS Ramaya College of Law, Bangalore, and ML in intellectual property rights from the University of Madras, Chennai. Later is practicing with independent practitioner until 2011. Later, he joined Samvad Partners as an associate and was promoted to senior association in 2021. He had immense experience in intellectual property rights, advisory and prosecution matters involving enforcement of copyright and design, implementation of contractual rights and liabilities arising out of a contract, insolvency of companies, etc. And thank you.
Thank you, Swati. Now I would like to call our chief guest, Mr. Pushkar Ravishankar, to give the speech about intellectual property rights and IP management for startup. So now you can take your mic, sir. Take on your mic.
Hi, good evening, everyone. Firstly, thank you for a warm welcome and for the brief introduction. Yes, as she said, yes, I've been practicing from the year 2014. And I've been focusing mainly on IP rights and IP prosecution over in Bangalore and in Chennai. Today, I'll be presenting on the topic of intellectual property rights and IP management for startups. So
Sir, you're muted.
it's audible now?
Yes, yes.
Yeah. Okay. Firstly, thank you for the opportunity and for a warm welcome. And as she said, yes, I enrolled myself in the bar in 2014, and I've been practicing in Chennai and in Bangalore for the last 8 to 9 years. To begin with, yes, today I'll be presenting on the topic intellectual property rights and IP management for startups. This presentation will be mainly focusing on the types of intellectual property that's available, an overview of these intellectual property, and how do you register these rights, what you have supposed to get it. Then how is it benefiting you? And also be focusing main on how a startup can utilize these intellectual property rights. Okay. Uh, so I'll just share a presentation that I have made. One second. Is my screen visible? Hello?
Yes, sir. Yes.
Yeah. Yes. Okay. So before beginning the presentation, I would just tell you what an intellectual property right is. Okay. So as the word itself says, it's intellectual property. Correct. Like any other property, what you see, like how immovable property is, how a home is, how a specific pencil is, how a laptop, anything. All these between those property and this particular property. That's the first thing what we should consider. Unlike the other properties, intellectual property rights are considered to be as intangible asset by itself. Okay. What do you mean by intangible asset? Intangible asset means an asset which you will not able to feel it, or you will not be able to touch, or it does not have any physical presence as such. Such being the case, it will be falling in the category of intangible asset, and intellectual property is an intangible asset. And I will be first focusing on what a trademark is and a copyright. Then I will be going on to design and patents. So apart from these four, like trademark, copyright, design, patents, there are so many other things also like geographical indication, plant variation. All these will also be considered as intellectual property rights. But the main focus here will be on these four topics. As I said, this presentation will be more of an practical exposure or with examples, so that it will be easy for you to understand the basics. Okay? If someone is not able to understand at some point of time, you can always tell me or ask me, or if you want me to start speaking in Tamil, I'm very much okay with it. Or I can just speak in both the languages, so it will be easy for both. Now, first and foremost, to see what a trademark is, what we should understand is what a mark. First and foremost thing is we should consider what a mark is. Okay. A mark can be anything. A mark can be a name, it can be a device, it can be a brand, shape of goods, label, packaging, anything. More to give you more practical example, there I have put in a specific flowchart or image which will give you an example of what a shape mark is. First one is a Coca-Cola bottle. The bottle shape of Coca-Cola is considered as the shape of the bottle is shape, right? So can you register or can you have rights over a specific design of a bottle? The answer is yes. If you have come up with your own design, then of course you can register it so that no one will be using a similar design. Okay. Next thing is the same Coca-Cola bottle. If you see, there is a name. Why do you call it as a Coca-Cola bottle? Even without the name being there, you all will know it is a Coke bottle, correct? That's because they have been using the same design for over a decade or 2 decades, or I guess it's now over some 5 decades now. So they have been using a similar design, a similar model, and they have been using a similar color combination, the red and white. So here with the first image, you can see the shape of the bottle can register and the name can register. So it will be a shape mark and a device mark. Also the word by itself, for Coca-Cola is also a word by itself, can also be registered under a word mark category. Next is your McDonald's. Like see how the McDonald's is not given, but still you all would know it is a symbol of a McDonald's. How would you know it? Because McDonald's has registered the symbol that saying that it belongs to them, and they have been advertising widely, right? They have been, it is their face. And the M பார்த்தாலே நமக்கு தெரியும், okay, McDonald's ஓட symbol தான தெரியும். Correct? That's because they have been using it for quite some time. So a specific symbol can also be registered. Next is a slogan. Slogan here is I'm loving it. In the most of the McDonald's symbol பாத்தீங்கன்னா அது கீழ இருக்கும், or டிவில அட்வர்டைஸ் பண்ணும்போதோ or பேப்பர்ல அட்வர்டைஸ் பண்ணும்போதோ இது போடுவாங்க. Why? Because அந்த வேர்ட் சொன்னாலே okay, first thing that comes to your head is McDonald's யூஸ் பண்ணுவாங்க இது. So therefore you can register a specific slogan also. Next is a color mark. There will be certain things. So சொன்ன மாதிரி Coca-Cola கரெக்ட்டா ரெட் தான் யூஸ் பண்ணுவாங்க. They will not be using a green Coca-Cola or they will not be using a blue Coca-Cola. So similar way, in your example orange protocol, this is a company by itself. They specifically use this color orange for which you can claim rights. Next is a logo. Volkswagen pathina and the specific logo were registered பண்ணிருப்பாங்க so that no one else can use it. So these are the different types of trademarks what one can register. Packaging சொன்னேன்னா packaging also can be registered. Recently நான் ஒரு கேஸ் என்ன பார்த்தோம்னா like bubble wrap பார்த்திருப்பீங்க எல்லாருமே. Now this one client of mine has come up with a new thing called eco wrap. That's mainly made of paper. Bubble wrapல என்ன facility இருக்கோ அதோட protection அதிகமா இருக்கும் just by making cuts in a paper. So அவங்க என்ன பண்ணிருக்கா, now he has registered himself for patent for a unique design. He has registered himself under designs itself because of how its functionality is. Next, packaging. So in packaging, he has also registered for trademarks of his company. Adhanala it's all these trademarks, copyright, designs, all will not collide, but at times they might collide with each other. நீங்க ஒரு ப்ராடக்ட் வச்சு ரெண்டு ரைட் வாங்கலாம். You can claim for both. You can register itself under a copyright or you can register itself under a trademark. ரெண்டுமே வாங்கிக்கலாம். But there is a certain differentiation which I will be coming in some short while. For next, what is a trademark? So trademark is a source identifier, and it should be distinctive to its product or service. For main classification, கீழ பாத்தீங்கன்னா classes போட்டிருப்பேன் 1 to 34, 35 to 45, which means classes 1 to 34 will indicate the goods, 35 to 45 will indicate services. Main all these classes have been there followed throughout the world. All these comes through international treaties which every country is bound to follow. அது கீழ specific class இருக்கும். Classes எப்படி சொல்ல, now say that நீங்க ஊதுபத்தி register பண்ணனும் வெச்சுக்கங்க. ஊதுபத்தி will fall under class 3. You should be registering your and the specific ஊதுபத்தி or what we call as incense sticks specifically under class 3. So that will give you rights under class 3 itself and not over all the other classes. First. Next is source identifier. Now what do you suppose? So McDonald's same pathale உங்களுக்கு தெரியும், like it belongs to McDonald's. That is the identification for its source. If you see it is how do you differentiate between a label or device? For label or device also it's always called as together. For label Coca-Cola, the entire thing they will be registering it as a label. இப்போ எந்த சாப்பாடு பொருள் எதுவா இருந்தாலும் பாத்தீங்கன்னா லேபிள் ஒட்டியிருப்பாங்க. The entire label you can register as a label mark, or இப்போ logo மட்டும் இருக்கும். Like how this Jeppiaar college has a logo for itself. So college logo can be registered as a device mark. That's a broad difference. But next, copyright. Now, all trademarks can be copyrighted, but all copyrighted material cannot be trademarked. For copyright, now say that first thing that comes. So, as a startup, first thing what comes to your mind? Startup na first thing that comes. Okay, now na enna pannanum po first or idea irukum. I would want to materialize that idea. I would want to start a company, or I would want to promote my brand, or I want to do business. That's the main idea, and earn money. That's of course the ultimate goal. So now, as an idea by itself can be registered under Copyrights Act. Or idea, okay, if you say that specific pencil or pencil and naal color same pencil. Such being the case is an idea what you have, or for a movie script writing scripts, all the scripts can be registered as an idea under copyright. Anga arambichonna, again there is something called an artistic work. Now in the Coke bottle of Pathinale, there is a work involved. It's not like any other bottle. There is a specific artistic work involved. So this artistic work can be recognized under copyright law. It can be registered for copyright. Similarly, we can also be registered under Designs Act, which I will just come to in a short while. For basic idea trademark, these are different types of trademarks. It can register panikla, or copyright. It can be an idea. It can be any specific artistic work, design, drawings, whatever you think is not fun, it should be an original work. For book என்னதான் 10 பேர் புக் எழுதியிருந்தாலும் அந்த 10 பேரோட காப்பி அடிச்சு அங்கங்க ஒரு புக்ல இருந்து ஒரு பேராகிராஃபா எடுத்து நானா ஒரு புக் போடுறேன்னா ஈவன் தட் ஃபார் தட் பர்టిక్యులர் புக் யூ கேன் கிளைம் காப்பிரைட். அதனால எவ்ரிதிங் கேன் ஃபாலோ அண்டர் காப்பிரைட், பட் you should ensure that you have your registration done under any of this IPR rights what's available to you. But next, I will tell you what a good trademark is. In the word, but explain what a mark is. First thing, what mark? The name, brand, device. எதுவா இருந்தாலும் register பண்ண முடியுமா? இல்ல. There will be certain things you can register, certain things you can't register. Correct? How can you register? First thing, a mark should be distinctive and coined. இப்போ நீங்க create பண்ணதா இருக்கும். நீங்க வந்து வேற ஒருத்தர் first time வச்சிருக்கான், அதை பார்த்து நான் காப்பி அடிச்சுட்டு I can register it under a trademark. Right? Because he will be having his own rights since he has come up with it. Now, how do you call it as distinctive? For Amul, what does the expansion of Amul mean? Has it to do anything with the products what they have been serving? It's a product vechirukanga. Amulna, and the word stuck in a word path ella products nya varuma. What does it describe as such? Ibacco, ice cream they're serving. And Ibacco ice cream kenna sambandham. There won't be any link between the word Ibacco and ice cream. Correct? Next, a mark should not be descriptive. An example கொடுத்திருக்கேன், one is sun away sunscreen. Now, sun மேல படக்கூடாது, அதனால sunscreen. Now, how will you be able to register this particular trademark? The answer is no. It can't be a direct answer. பேர்ல சொல்லக்கூடாது அவங்க. Sugar free for sugar substitute. Sugar free adல பார்த்திருப்பீங்க. Sugar free இந்த mark register பண்ண முடியுமா? முடியாது. Because it's not a good trademark at all. It's a descriptive. It's a sugar free substitute for sugar. How can you register? It should be coined or it should be descriptive. It should be distinctive and not descriptive. But next pathina, it should not be generic. But generic na pathina, now see, Xerox. Xerox na enna thonum, first thing what comes to your head. Xerox machine irukum, Xerox edupom, seivom, that's all, correct? But Xerox by itself doesn't mean நீ கடையில போய் காப்பி எடுக்கிறது. Xerox means it's a brand. They were the first one to come up with a copier machine or a printer machine. Over a point of time, நம்ம எல்லாருமே photocopy ன word மறந்துட்டு we started using the word Xerox. And Xerox company did not take up any protective action against the infringers. Infringer I will definitely say what infringer is. Infringer is a person who is copying your mark or copying your work or copying anything that you are doing. Correct? Through which he is gaining some benefit out of it. Either it can be a monetary benefit or it can be name, fame, anything. So here, Xerox company, when they did not take action against everyone possible who were trying to infringe their mark, automatically it became generic. So now Xerox company cannot file actions against everyone who is using the word Xerox. Adhanal, you should be also taking actions as to whenever there is infringement happening, you should ensure that you take action so that you can protect your mark. Now, இது வரை புரிஞ்சிருக்கா? Basic idea what a trademark copyright is?
Yes, sir.
Okay. So next I will be telling you how a registration process is. I will not be elaborating in detail. And I overview how a trademark is. Now to have a trademark registration, first thing is trademark search panano. I will explain more about trademark search in the upcoming slides. Your first application file pannu, application will be examined by an examiner in the trademark registry. If they think that yes, this is a good trademark, they will be processing the registration process. If they think no, it is a good trademark, there will be a hearing. If you convince the officer, okay, this is a trademark, they include a own work, this is a coined work, this is a distinctive work, then it gets published in the trademark journal, which will be available there in the public domain performance. Say that now Jeppiaar college has their own name which they have been using for quite some time. Can I start a college with a similar name, or can I apply for a registration? Now say that if I have applied for registration and I have convinced the officer saying that in the pair nanda vechen enoda own work iduna, the 4 months journal publish pannirpaanga, then the concerned person of Jeppiaar college they should be opposing this registration of mine, so that they can tell the officer that no, the mark belongs to them and no one else. Oppose pannanga, there will be an opposition proceedings and konja naal pogum. Once the opposition process over, and if the concerned officer is convinced that yes, you know the work, then the mark will be registered in your name. Once the mark is registered, the R symbol use pannalam. The R code round poran pathina, that can be used next to your mark. Suppose an application port 10, I should tell the world that yes, I have given my application or I have filed my registration process. Then TM na solli use panikalam. நீங்க எந்த கடையில பாத்தீங்கன்னு வச்சுக்கோங்களேன், மெயின்லி everyone started using. Starting எல்லாம் யூஸே பண்ண மாட்டாங்க. Even if they make application, TM ன word மேல யூஸ் பண்ணிருக்க மாட்டாங்க. These days எந்த கடையில பாத்தீங்கன்னாலும் along with the logo the TM ன மேல போட்டுருப்பாங்க. இதெல்லாம் நீங்க ஃபோக்கஸ் பண்ணலனா இப்ப ஃபோக்கஸ் பண்ணி பாருங்க. There will be many shops, அந்த brand name மேல பார்த்தாலே they will be put TM or like RH போட்டுருப்பாங்க. That is to assert their right, saying that என்னோட மார்க் தான் இது, என்னோட லோகோ இது, you cannot use it. அது சொல்றதுக்காக தான் ஸ்பெசிபிக் இது போடுறாங்க. For trademark, once registered, it will be valid for 10 years. Adukapra subsequent every 10 years you register renewal pannite pogalam, so that you will be holding its rights. Now advantages, main advantage enna, now should I register for trademark or not? Na edhukku register pannu, enakku theriyum enoda right dhaan, the street elladhukku theriyum enoda kada dhaan, enoda kada per idha vechiruken, the per sonal oor full ah theriyum enoda dhaan. See, if you think in such a way, then you will never have a right, or you will never have an overall perspective, correct? Or you cannot go outside the particular street or area. For registration panna enna agum, there will be two things. One, for registration pannala, anona someone else will be using my mark. Will I have a right over them? For registration pannirken, adukapra should I take action? Question nariya varumla, registration pannala, how will I file a case against him? Correct? So trademark law la pathina, even if you don't register your trademark, you will be still eligible to take an action against infringer. Yeah, but the problem is, first in court podingna, you should be convincing the court that in the mark ungalodu solittu. First court should be convinced. Adukku first there will be separate proceedings happening saying that yes, in the mark ungalodu dhaan theriyadhu. Once the court is convinced, then the court will take action against the infringer. Against case file pandringo, then normal proceedings will start. But if you have a registration in your name, automatically the step is skip pannilla. Automatically it gives you a right saying that you are the one who is the owner of this particular trademark. Adanala, yes, is exclusive use kadaikum. That say that neenga now say you are using in McDonald's as examples, oh, McDonald's, what all do they sell? They have specific McBurger. Burger matter which they can't have a specific right over all the other burgers that's been sold in the market. They will be having a specific McBurger. In the kadila ponala, they have their own burgers. Burger King ponala, Singapore they have own burgers. To say that they are the ones who has come up with a particular type of burger, which no one else should come up with. Adhanala avanga per potu and the burger vikranga. So that there will be exclusive use for that particular product. Second thing is easy execution against duplication. So நம்ம registration இருந்தா prima facie evidence இருக்கும் saying that the mark உங்களோடது சொல்லிட்டு. Next, registration is mandatory for e-listing in any website. So since considering இப்போ நிறைய பேர் ஸ்டார்ட்அப்ஸ்னா இப்போ நீங்க கம்பெனி ஆரம்பிக்கிறீங்கன்னா now any government website நீங்க ப்ராடக்ட் லிஸ்ட் பண்றீங்க or if you want to list your product on Amazon, Flipkart, எங்க போனாலும் now they have made it a mandatory that you should be having a compulsory கேக்குறாங்க. அதனால if you are a startup, even before approaching these markets, you should be having a right for yourself first, for which you should be filing an application. But next, அதே மாதிரி trademark every 10 years renew பண்ற மாதிரி copyright once you register பண்ணா it will be valid till the lifetime of the author and for 60 years after that. So copyright, there is a much broader protection. But நிறைய பேர் ஐடியா வந்தாலும் காப்பிரைட் அப்ளை பண்ணிடுறாங்க. ஐடியா ஒர்க் ஆகுதோ கிளிக் ஆகுதோ இல்லையோ செகண்டரி. First idea irukku, no one should do. That's what happens in all movies. Or movie varudana, automatically you should check first whether they have copyright registration for it. They have an artistic work done to it. For any movie, any random movie eduthukanga. Now say that jewelry which they have used in PS2 or PS1. Ponniyin Selvan pathina, all those specific jewelry are a unique design by itself. யார்கிட்டயுமே அது இல்ல. அவங்க எல்லாமே ரெஜிஸ்டர் பண்ணிருக்காங்க. They have a rights for all those jewelry. They have rights for the script what they have used. ஏன்னா இது is not a script by itself where they have creating a movie out of a novel. இல்ல, they have made many changes to the novel. Thereby this itself falls as a new category or new work. Register பண்ணிருக்காங்க. They have registration for everything, so that no one else can use it. Once you have a registration for this, இதுக்கு அப்புறம் வெளியூருக்கு லைசென்ஸ் பண்ணுவாங்க. How does the remake movie come into picture? Correct. Once the director or the producer here will have a rights over any work what they have done, then they will start giving it to the other directors, other producers, where they can make their own movie. இது எப்படி பண்ண முடியும்? Only if you have a right, you can assign it to someone. Okay. Course, for trademark registration பெரிய கம்பெனி தான் பண்ணுமா, சின்ன ஸ்டார்ட் அப் பண்ண முடியுமா, ஸ்மால் என்டர்பிரைஸ் பண்ண முடியுமா, or இண்டிவிஜுவல் தான் எங்க கம்பெனில என்னால பண்ண முடியுமா? Answer is yes for everything. Anyone and everyone can register. An individual on his own name he can register, or partnership firm இருந்தா அவங்க ரெஜிஸ்டர் பண்ணலாம், கம்பெனியா இருந்தா அவங்க பேர் ரெஜிஸ்டர் பண்ணலாம், டைரக்டர் யாரா இருந்தாலும் பண்ணிக்கலாம். Only condition is it should be your work. வேற ஒருத்தவங்களோட work உங்களால ரைட்ஸ் claim பண்ண முடியாது. So ensure that it is your work. For more examples சொல்ல போனா, now see these examples will tell you that okay இந்த மாதிரி trademark register பண்ண முடியாது. Now, first is visual similarity. இதுல பாத்தீங்கன்னா plaintiff is the original person, defendant impugned mark is the duplicate person. Monaco பாத்தீங்கன்னா craco ஒரே மாதிரி இருக்கும் கிட்டத்தட்ட, which means this virtual similarity. Second thing, hide and seek, peekaboo ஒரே மாதிரி. This is all imitation. But டக்குன்னு பார்த்தேன்னா தெரியும், ஓகே இந்த கலர் பார்ப்போம், ராப்பர் கலர் பார்ப்போம், இதா இருக்கு, உன்னாவுக்கு சேம் எடுத்துட்டு போயிருவோம். அதுக்கப்புறம் நம்ம போய் உத்து பார்த்தா தெரியும், ஓகே போத் ஆர் டிஃபரெண்ட், நம்ம ஹைட் அண்ட் சீக் வாங்கல, வேற வாங்கிட்டு வந்திருக்கோம். Which is prohibited under law. இதெல்லாம் பாத்தீங்கன்னா the wrapper itself, they would have been registered as a label mark. The wrapper full register பண்ணிருப்பாங்க. Next is crack jack, அதே மாதிரி cracker king ஒரே மாதிரி இருக்கு பாருங்க. This all amounts to visual similarity. Next is phonetic similarity. பூமா கோமா நிறைய இடத்துல பார்த்திருப்பீங்க டூப்ளிகேட் ப்ராடக்ட்ஸ் பார்த்தாலே தெரியும், PUMA இருக்காது, POMA இருக்கும், PMUA இருக்கும். All this giving a phonetical similarity or a visual similarity so that they can deceive the people. Nike, NUKE, tick right to left இருக்கும், left to right இருக்கும், just to confuse people so that they can take advantage of this. All these type of registrations are prohibited. Okay, this you cannot register. That's the main thing. Next is infringement or counterfeit products. For McDonald's, in the first example image la pathina McDonald's உங்களுக்கு தெரியும், that's the original thing which is there. பக்கத்துல McDowell's அதே மாதிரி M இல்ல, but it's a similar kind of M and a similar kind of wordings. But டக்குன்னு பார்த்தா உங்களுக்கு டிஃபரன்ஸ் தெரியாது, நீங்க 2 செகண்ட் மேல ஊத்து பார்த்தாதான் தெரியும், ஓகே இது McDonald's இல்ல இது McDowell's சொல்லிட்டு. Such kind of thing will also amount to trademark infringement. Next is counterfeit product. E-edition copy சொல்றோம்ல, exact copy, ஒரு இது பார்த்து அப்படியே காப்பி பண்றோம், which will amount as counterfeit products. நிறைய duplicate product பார்ப்பீங்க, all for Under Armour or your Nike or Puma, எது பார்த்தாலும் there'll be duplicate product. Those are counterfeit products actually. They would copy exact the same design material so that they can confuse the buyers who think it is original. But next, remedies. Now, in the remedies, the same for all types of trademarks. In the trademark registration, say that you want to take action against infringer, then these remedies are same. First thing, you can file a separate case in a trademark registry whereby the process how a registration process works, and the file panni, you can claim your rights. Or you can file a case before any court, any commercial court or district court. Younger location, say that you are residing in Chennai, then you can file in Chennai. Or say that your business is there in Bangalore and in Bangalore file பண்ணிக்கலாம். அதுக்கப்புறம் appeal process எல்லாத்துக்கும் தெரியும் how a court system works. For commercial court, அதுக்கப்புறம் again high court, அதுக்கப்புறம் supreme court. The process will take its own sweet time. Depends how fast you can take a remedy. In action எடுக்கலாம் against these infringers. You have two actions. One is a civil remedy, next is a criminal remedy. Civil remedy, first and foremost, is a temporary and permanent injunction. Temporary injunctions, as the name itself says, it's only a temporary relief that you are getting. Usually, court case file starting as a temporary relief, and that particular relief or injunction that they have been granting will be available till the end of the case. Injunction next. Injunction is an injunctive order. Okay, now idni panna kudadu. Something which stops someone from doing is called injunction. Now, this injunction starting it's a temporary or case I have decided that you are just infringing the infringer. Defendant should not be using plaintiff's product. You are permanently injuncted. Yes, it's a permanent injunction what the court has granted. Apart from that, there is something called raid and seizure. In the court, okay, I'm use product, product seize அதுக்கு நீங்க ஒரு கோர்ட் கமிஷனர் அப்பாயிண்ட் பண்ணுவாங்க. யூசுவலா கோர்ட் கமிஷனர் அப்பாயிண்ட் பண்ணி கோர்ட் கமிஷனர் will go to these premises. In கோர்ட் ரைட் நடக்குது பாத்தீங்களா, how an IT raid, anything is happening. Similar way, அவ்வளவு பெரிய ரைடா இருக்காது, but this will be, yes, with the police protection. You will be going to a particular factory wherever this infringing product are being manufactured. Then through the help of the police, you will be able to seize all the goods. That is raid and seizure. Next is dehosting a website. For dehosting website, now all know, okay, now McDonald's.com. McDonald's.com has been owned by the company McDonald's. Now, can I have a website called McDonald's.in or McDonald's.oo or McDonald's.eu? You can. GoDaddy website. In the website, now we have got to know. Now say that you will be having something called Jeppiaar University or IN there. You won't be having .com. Rates also differs. IN someone will be registering it for .com. Now who created the website first? Other base panni court locating, then court will of course direct the other person to dehost the website or transfer their website to you. Next, removal of impugned mark from other websites. Civil remedies civil remedy courts now say Just Dial or India Mart or Amazon, there will be area sellers will be selling a very similar name. Then you can ask a relief against all these sellers to stop selling from this particular platform. Amazon is sell pannakudaadavanga, so injunctive relief kekkalam. Next, damages. Of course, ungaloda product for your business, unga product vaangama avanga product vaanguvaanga, apdi irukumbodhu there will be financial loss to you. So damages can also be claimed. Next is this John Doe relief that can be claimed whereby road la paakalam. No solreenga Nike nariya per use pannanga duplicate. How will you know who is selling it? Ungalku theriyave theriyadu. Such being the case, the John Doe order vaangittu, then you can go approach the court. Court John Doe order kodupanga. Then you can approach the police to have a immediate raid on all these properties and all these goods, so that the goods will not be there in the market. Apart from the criminal remedy, you can directly go file a police complaint. Nariya police station it's a civil case, directly go to court. But here, intellectual property rights, if there is a registration and if there is an infringement, criminal case will file panna. And courts, of course, courts will be in favor of you. Also, the police will help you in seizing the goods. As I said, this particular remedy is all for all different types of intellectual properties and not specific to trademark or copyright. But next, transfer of rights. Starting sonamari, na right vechirken, trademarks owned by me. Can I give it to my brother, or can I give it to my sister concerned, or can I give it to someone else? Yes. This transfer of rights will happen in two ways. One is by way of assignment, second is by way of a license. Assignment entire thing you will transfer it to them, saying that yes, you are the exclusive user, when I use you use panna. Licenses the exclusivity. Say that now I can give the distribution of my particular product to in Tamil Nadu to a particular person. Adhe mari, I can give it in Maharashtra to some other person. So like now, okay, in the goods niye manufactured puni niye vithikalam, for which you can use my trademark. It's a license which you are giving. Also, assignment is with goodwill or not without goodwill, which now say, for example, for lion dates, lion dates, they mainly manufacture dates. Apart from that, they have honey, 10, 20, 30 products. Such being the case, they can license a particular thing, or they can assign a particular manufacturing alone to someone. Dates now, 9 dates, honey can be manufactured by someone else, but they can sell it on the same name of lion dates. That is called assignment without goodwill. Main goodwill licensing for manufacturing. That's more difference. But confuse yes, rights can be transferred subject to certain conditions and consideration. Of course, you will be compensation for some specific sum. For next is for now, this what I was speaking is with respect to trademarks and copyrights. Next is patents. Now, as a startup, all you will be doing, you will be engineering students. Now, engineering students will come up with their own products, own design, specific way as to how a product is. For patents are not like all big equipments, machinery. There are ways where even a software program can be patented, subject to certain conditions. The software program will be copyright. Now, example, now even bottles. Bottle, how do you open a bottle? How a bottle functions, even that can be patented. Or now say a diaper. The products, what they use in the diaper, or the material, what they use in the diaper will differ. So in the material used panna, how will the function be? And they explain panamodi, yes, you can have a patent right. Patent main thing that requires is patent should be new. Same thing I cannot do, which I have explained earlier for trademark or copyright, same thing. It should be new, or it should be inventive step, and it should be of industrial application. Say no, our product vechirken. Adu use panna mudiyadhu. Appdi irukumbodhu patent kadikuma enakku kadikadu. There should be an industrial application where people can use it. A useful product irukano. Even anything, dustbin, how a lid opens, closes, how the process works. Now say that there is a specific dish which restaurant has made. Adu patent panikla. The process, how they make it, even that comes under patent. But the process or the finished good or the functionality, whatever you think, yes, nanda panne, it is new and no one else has done it, then you can register for patents. Therefore, it should be a novel packing technology. Recent our clients like how bubble wrap, ilama paper they have come up with a wrap. That's an inventive step. The way how they have used it, the cuts, the shape of cutting, how the paper expand contract all this is a patentable step or a novel step. So once you have come up with such things, yes, then patent can be registered. For all these intellectual property rights are territorial rights. See, these cannot be now in India. I should register. Now say that you are going to other countries, say Malaysia, Singapore, Sri Lanka, for example. You should be registering it there. That is very important. For example, now say that now the mangoes, specific, okay, mangoes, specific mango, Salem mango. Salem mango na inga vikkurenna. Now say that for which I will be having a specific name for my company. Correct? Na inga distribute pandren, inga for abroad, Malaysia distribute pandren vechikalam. Usually enna pannuvom, any small company will engage a distributor there. When distributor supply பண்ணப்பன அவன் என்ன பண்ணுவான், ஓகே இந்த ப்ராடக்ட் நல்லா போகுதுன்னா உங்களோட ப்ராடக்ட் நேம் அவனே மேனுஃபேக்சர் பண்ணி அவனை விற்க ஆரம்பிச்சிருவான். See, certain things not possible. Salem mango Salem மட்டும் தான் வரும். That's fine. But what if he comes up with something and he's able to produce the same types of mango there? or now say for ஊதுபத்தி example எடுத்துக்கங்க. ஊதுபத்தி தெரியும் எவ்வளவு flavors வருதுன்னா. Now same the fragrant he can also manufacture it there. Unless until you have a registration right over here. அப்படி இல்லாட்டி he'll be doing the same thing there. அப்ப என்ன பண்ணுவீங்க? First and foremost, you should have a registration in that particular country even before even venturing into the specific country. Okay. Therefore, this is a territorial right. Patent trademarks 10 years சொன்ன மாதிரி, copyright 60 years சொன்ன மாதிரி, patent it is 20 years validity. After that, rights will come into a public domain so that anyone can use it. The process for application of a trademark or a process for application for a patent registration is almost similar, but just the scrutiny will be differing depending upon the inventive step. Now, one more main thing what you should all know, considering that you all are into college and what you should be doing. But நிறைய ideas வரும் உங்களுக்கு. Okay, இதான் நான் பண்ண போறேன். This particular product will function in this particular way. அப்படி இருக்கும்போது you say that if you go to a seminar, college seminar conduct பண்ணுவாங்க, say that you are calling people from outside college, நீ go present பண்றீங்க, saying that I have come up with a new product. ATM machine இதெல்லாம் பண்ண முடியும். பேங்க் நீங்க போக தேவையில்லை. ஒரு மிஷின்ல everything can be done. இந்த மாதிரி எந்த பேங்க்குமே ப்ரொவைட் பண்ணல. அப்படி say that you have come up with a new product. If you make a disclosure in public, disclosure பண்ணீங்கன்னா, then you will not be able to register under patent rights. As I said, first and foremost, எதுக்கு நான் திரும்ப திரும்ப யூஸ் பண்றேன்னு, even before telling it to someone, you should be filing an application at least saying that you are inventing such a product. So நல்லா வச்சுக்கோங்க, நீங்க வந்து எல்லாத்தையும் டிஸ்க்ளோஸ் பண்ணிட்டு, or say that you have written an article about this new product. Article எழுதுனதுக்கு அப்புறம் then you can't go file for patents. Therefore, first நீங்க அப்ளை பண்ணதுக்கு அப்புறம் தான் you can even disclose it to public. So that is very much important. Advantages என்ன? As exclusivity சொன்ன மாதிரி உங்களுக்கு எக்ஸ்க்ளூசிவா நீங்க யூஸ் பண்ணலாம், competition tackle பண்ணலாம் so that no one else can use it. Obtain funding. See, funding is very very necessary for a startup. Correct? உங்களுக்கு காசு இருக்காது. Such means எங்க இருந்து காசு வரும்? Once you apply for a registration, you can pitch your product to anyone, to any funder, or there is so many other corporates who will be ready to willing it or integrate your product with them. But நிறைய companies in Bombay, Singapore, or in fact even in Bengaluru, they'll say that if they find some product to be useful, immediately they go acquire that product. Correct? Any acquisition, WhatsApp, how did Facebook acquire WhatsApp? Because they thought, yes, this is a product that will do well. Immediately acquire பண்ணுவாங்க. So for which you should have a registration for yourself and tell them, yes, it's my own product and I have a right to it. That's very important. For next, design. Patent is same. One thing what you should know is that you should be new, you should not be making any disclosure to public, and there should be inventive step. For design. But design in the particular image series, I guess it just take a random guess as to what this design is. Anyone? Any random guess as to what this design is? Or the functionality of this design? எதுக்கு நான் போட்டிருக்கேன்னு சொல்லிட்டு. ஹலோ, இருக்கீங்களா?
இருக்கோம் சார். டிசைனுக்கு வாங்குற ரைட்ஸ் சார். எக்ஸாம்பிள்
இது டிசைன் என்ன ப்ராடக்ட் சொல்லுங்க. Tell me what product is this? சரியா தெரியல. Correct. So the design பாத்தீங்கன்னா, this design is a ஊதுபத்தி stand இது. So they came up with a unique design for the ஊதுபத்தி stands. இது வந்து ஊதுபத்தி stand. இந்த ஓட்டருக்கு பாத்தீங்கன்னா மேல ஊதுபத்தி வைக்கிறதுக்காக இது. So the specific design is a new thing which no one else is using. அதனால you can claim design registration. But design சொன்ன மாதிரி நான் சொன்னேன், jewelry same way, ornamental purpose, any jewelry can be, specific design can be registered. Shape of this jewelry or pattern, 2 dimension, 3 dimension, specific mouse வச்சிருக்கீங்க. Mouse and the design யார்கிட்டயுமே இல்ல. You have come up with a unique type of mouse which can be handled easily and smoothly. You have to register for design. Register பண்ணனும். It can be any dimension, 2, 3 dimension எதுவா இருந்தாலும் பரவாயில்ல, but there should be a specific form to it. IPL நடக்குது. Recent ஒரு client வந்தாங்க, they have a miniature of all big IPL players. Miniature வச்சிருக்காரு. He wanted to register that miniature so that no one else can use a similar design of the miniatures. அது எதுவா இருந்தாலும் பண்ணிக்கலாம். There should be a design, there should be applicability to the design. Those are the two main factors. Patent என்ன சொன்னீங்கன்னா, it's very, very similar to design. It has to be inventive, should be new. It is a territorial right. Patent வந்து 20 years மாதிரி, design is valid for 10 years. அதுக்கப்புறம் 5 years extend பண்ணிக்கலாம் from the date of filing, because that's how they give you rights. The registration process is almost similar as to how the other registration processes. அதனால நான் repeat பண்ணல. Advantages is also very same. அதனால அதை repeat பண்ணல. I'm just skipping that. What you should know is design there are many H&M, Zara la பாத்தீங்கன்னா they have like hundreds of design registrations. எதுக்கு? For the unique dress. Correct? Fashion show la வருது பாத்தீங்கன்னா all the dress. Every dress there is a registration, there is a copyright registration, or there is a design registration for each dress, so that no one else will use it. For specific actors when the dress போட்டுருக்காங்கன்னா, how do you know? வேற யாராவது அதே dress போட்டா how will you know? Correct? It's a unique dress by itself. The designer would have registered the specific type of dress under a Designs Act. Registration illati anyone can use it, so that he will lose his registration. So kandipa pannirpar. That you should be knowing. Next, IP international protections. International protection and detail explain panla. I will take very small, this 2 minutes I will skip this, because for a startup, first you should have a registration in India. As a home country, you India registration pannunga. Adukappuram then you can go to other countries. Trademark is governed under Paris Convention. Paris Convention, Berne Convention, like overall, all countries in the world would have registered or would have signed this convention, saying that okay, நீங்க என்ன law போடுறீங்களோ அதே மாதிரி எங்க countryல நாங்க law create பண்ணுவோம். We'll have very similarity, so that it will be equal representation all over the world. சொல்லிட்டேன். Trademark, patent, design, all are covered under Paris Convention. Copyright is under Berne Convention. I'll just skip this for now. Next is the main thing now, startup. Now, as a startup, what you should do, correct? Starting சொன்ன மாதிரி, yes, உங்களுக்கு ஒரு ஐடியா இருக்கும், saying that இந்த business தான் பண்ண போறேன், இதுதான் என்னோட startup சொல்லிட்டு. அப்படி பண்ணும்போது first and foremost உங்க ஐடியாவை register பண்ணுங்க. Please register your idea under copyright, saying that இதுதான் என்னோட ஐடியா. This is how my product will function, or this is how my company will function. Peer-to-peer model, or consumer to, or a manufacturer to consumer, direct to consumer. எதுவா இருந்தாலும் how will a model work? ஐடியா இருக்கும், ரெஜிஸ்டர் பண்ணுங்க. தென் எஸ், நெக்ஸ்ட் என்ன? நெக்ஸ்ட் நேம். உங்களுக்கு ஒரு கம்பெனிக்கு நேம் வேணும். நேம் நீங்க வந்த உடனே ஃபர்ஸ்ட் திங் வாட் ஷுட் டு இஸ் a trademark search. Trademark search எதுக்கு நீங்க பண்ணணும்? Now say that I have come up with a name called XYZ. நீங்க சொல்ல முடியாதுல, இந்தியால யாருமே இந்த XYZ நேம் இல்லவே இல்ல சொல்லிட்டு சொல்லவே முடியாது. There will be so many of us, so many persons would have registered the name XYZ. For example, Dove நீங்க சொல்ல ஓகே நான் தான் அந்த Dove ப்ராடக்ட் first name யூஸ் பண்ணேன் நானு, யாருக்குமே இல்ல, but according to you no one else is using, but உங்களுக்கு தெரியாது. Now say that the companyக்கு அந்த பேர் வச்சிட்டு then you start manufacturing everything with that name, products எல்லாமே label ஒட்டிட்டு, then you get to know someone else is also using Dove, who's been using much before you. அப்படி என்ன ஆகும்? Then automatically whatever products நீங்க என்ன பண்ணீங்களோ விற்க முடியாது Dove நேம்ல. It will be a problem. அதனால you should first and foremost do a trademark search to get to know that is someone else using a similar name or not. Then you will get to know, okay, in the name யாருக்குமே இல்லன்னு உங்களுக்கு தெரியும் போது, then you can start using that name. Similar logo also, in the particular logo யாருக்குமே இல்ல, then you can start using it. So trademark search press பண்ணீங்கன்னா then you get to know. நேம் தனியா ரெஜிஸ்டர் பண்ணிக்கலாம், லோகோ தனியா ரெஜிஸ்டர் பண்ணிக்கலாம். சேம் ஸ்டார்டிங் என்ன சொன்னேன், எல்லாமே trademark ரெஜிஸ்டர் பண்ணிட்டீங்கன்னா then you will know this your product. Okay. So now why should you register? Registration will give you a right, will give you ownership, will give you protection. There will be so many other added advantages on Mari. You know, advantages on everything you will be getting at the initial days itself. Okay. Next, for mistakes. For main thing, உங்களுக்கு நீங்க ஸ்டார்ட்அப்னு சொல்றீங்க, இத்தனை ரெஜிஸ்ட்ரேஷன் பண்ண சொல்றீங்க, from where will I get my money? என்கிட்ட காசு இல்ல, that's why I'm a startup. என்கிட்ட கோடிக்கணக்கு லட்சக்கணக்கு காசு இருந்தா I will be established company. என்கிட்ட அவ்வளவு காசு இல்ல, such being the case, why will you register? நான் வாடி கம்பெனி இப்ப ஸ்டார்ட் பண்ணிட்டு அதுக்கப்புறம் when I'm going into profits, then I will register for trademarks. It's the mentality what any startup will have. That is the first mistake what you are doing in a கேட்டீங்கன்னா, because you are undervaluing your own business. Correct? நிறைய பேர் இருக்கும், கிளிக் ஆனா அதுக்கப்புறம் ரெஜிஸ்டர் பண்ணிக்கிறேன், கிளிக் ஆகாட்டி இதுக்கு ரெஜிஸ்ட்ரேஷன் பண்ணி காசு ஃபேஸ் பண்ணணும், which means you are not even valuing your own right. உங்களுக்கு கான்ஃபிடன்ஸ் இல்ல. Such being the case, you need not even go venture into a startup. எதுக்கு பிசினஸ் ஸ்டார்ட் பண்ணும்? ஸ்டார்ட் பண்ணாமலே இருக்கலாம்ல. So there should be confidence. அதே மாதிரி how will the consumer get a confidence on you? Once you have a trademark register, they know, okay, இவங்க யூனிக்கா வச்சிருக்காங்க, யாருக்குமே இது இல்ல, they own this right. இந்த ப்ராடக்ட் சொன்னாலே எல்லாத்துக்கும் தெரியும். That's the first thing. So first, don't undervalue your IP rights. Initial days, starting வந்தோடனே yes, IP registration க்கு separate fund வச்சுக்குங்க. That is mandatory. Company registration க்கு there will be a separate funding which is required. Company registration is a process by itself where it will require certain financial help. Yes. அதுக்கப்புறம் next comes your IP. இப்போ நிறைய பேர் IP first register பண்ணதுக்கு அப்புறம் தான் கம்பெனி பேரே ரெஜிஸ்டர் பண்றாங்க. நான் சொன்ன மாதிரி trademark search so that no one will know. First பண்ணணும். That is the first and foremost. Next, not creating IP strategy. சொன்னேன்ல, ஓகே ஐடியா இருக்கு, இந்த ஐடியா நான் எக்ஸிக்யூட் பண்றதுக்குள்ள வேற ஏதாவது ஐடியா வந்துரும். So we'll never know. அதனால you should register your idea. That's the strategy what you make. Okay, first ஐடியா இருக்கு, நான் கார்ப்பரேட் ரெஜிஸ்டர் பண்ணிடுறேன். அதுக்கப்புறம் once I get a company name, then I register under trademarks. That's the strategy what you make. இல்ல இந்த ப்ராடக்ட் ரொம்ப நல்லா இருக்கு, no one else has come up with this product, then yes, go file a patent. Cost for all these certain things is expensive, certain things is not. அதனால if you think that is still expensive பண்ண முடியலனா, then you will never get a right over anything. இப்போ பேட்டன்ஸ் சொன்ன மாதிரி நீங்க ஸ்டார்டிங் யோசிச்சு இல்ல இது எக்ஸ்பென்சிவா இருக்கு நான் ரெஜிஸ்டர் பண்ணலனா, then you will not be getting a funding. Also by advantage of one more registering a patent is you get royalty. Now say that a license கொடுக்கிறேன், என்னோட ப்ராடக்ட் இது, you can manufacture it, now you can get license. நிறைய பேர் ஷார்க் டேங்க்ல பாக்குறீங்க, நிறைய பேர் வாட்ச் ஷார்க் டேங்க், you will know how these companies are valuing an IP. In fact, for asset காட்டலாம், intangible asset சொன்னேன்ல, you have a trademark registered, உங்க கம்பெனி அக்கவுண்ட் புக்ஸ்ல காட்டிக்கலாம், say that I have this intangible asset in my name. It will create a specific goodwill, then automatically it will have its own value. Now WhatsApp example சொன்னேன், WhatsApp எத்தனை பேர் ஒர்க் பண்ணிட்டு இருந்தாங்க வாட்ஸ்அப்ல? அப்போ Facebook அக்வயர் பண்ணும்போது not even 100, not even 50, just 48 or 42 people work பண்ணிட்டு இருந்தாங்க நினைக்கிறேன். How were they able to sell it for so many crores? ஒரே ஒரு ஆபீஸ் தான் இருந்துச்சு. How so many crores it was worth? Because of the goodwill what it has. How will the goodwill be created? Through this IP. அதனால this IP is very required, very much required. Without IP you can never sustain anywhere. But now you know what general mistakes a startup makes. Now please don't do this general mistakes what any other person does. Next, last thing I would say is, can I secure my IP through any random website which provides cost-effective solution? So now say that, now say for example, now any firm is charging you 10,000. Start online la pay paakreenga neenga. Now everyone goes to Google and searches what other people are charging. Google 999 போட்டுருப்பான் some random company. ஓ இவன் சீப்பா ப்ரொவைட் பண்றானே, I will go register under him. எதுக்கு நான் 10,000 கொடுத்து ஸ்பெண்ட் பண்ணணும்? Any thought, யாரா இருந்தாலும் பண்ணுவோம். நானே இன்ஃபேக்ட் of course I will search யார் சீப்பா கொடுக்குறாங்க, then think twice, only after that we'll proceed with that person, correct? But the disadvantages what you have with these people is, இப்போ நான் say for example நீங்க trademark register பண்ணனும்னா as individual the government fees 4,500. இப்போ கூட now immediately after this you go see how much is any random companies, online companies charging. They'll be charging 999 or 1299 or 1499. எப்படி? Of course பாரோ ஸ்டார் போட்டுருப்பான், எக்ஸ்ட்ரா 2 ஸ்டார் போட்டுருப்பான், all added value. Tomorrow they will be adding all possible charges to it, then overall picture வரும், correct? Also there are many people who cheat. Since everything has come online, application file பண்ணிருக்க மாட்டான், but still random number கையில கொடுத்துட்டு sir this is your registration number னு சொல்லிடுவான். Or application file பண்றதுக்கு முன்னாடி there will be some reference number உங்களுக்கு சொல்லிட்டு they will be like, okay sir this is your application number or registration number சொல்லிடுவான். And you will not have means to check it anywhere. நான் reference number வச்சு எதுவும் பண்ண முடியாது உங்களுக்கு. You need application number. எந்த application file பண்ண you need application number. அது உங்களுக்கு as a common man you will not know what the difference between reference number or application number or registration number உங்களுக்கு தெரியாது. So don't go with any random websites or any online registration where they say we will do it for cheaper price. You go with a person whom someone has referred you or their experience இருக்கு நிறைய பேருக்கு. Go with them. ஏன் சொல்றேன்னா online frauds எத்தனை நடக்குது. I don't want you as a startup to go fall for these frauds. First time will you have a very small funding with you. Capital கம்மியா இருக்கும்போது again you can't keep losing your money over these fraudsters. Same idea register பண்ணணும். What they do, they take the idea from you and they register under their own name. அது உங்களுக்கு தெரியாது. அதனால don't go with any online platforms is what my advice would be. So always you can approach any person whom you think has a knowledge about this particular subject. You can always approach them and have your rights registered. Okay, 7 o'clock so I'll just end my presentation here. For basic idea because different types of speed up on it because of time constraint also. So at least you know what different types of intellectual properties are available, how to secure your rights, and what you should do and what you should not do. For basic idea so that you can slowly start having some idea. So once you start going out of the college, or even during the college, if you think you have come up with something new, or if you think that you will be starting something new, you can always register your idea or product or design, logo, trademark, anything under the consent provisions of the law. Either question to the kekla, if you want me to explain certain topic again, also I can do it.
Thank you, sir. Thanks for spending your precious time for us, sir. It was very helpful.
Yes. Either questions irka, or
Okay,
you can end.
now I would like to invite Lalita from First BCom and to give the word of thanks.
A very good evening to all. It gives me an immense pleasure to deliver the vote of thanks for this event to all assembled here. I would like to thank our chief guest advocate, Mr. Pushkar Ravishankar, Sir, IPR consultant and lawyer, who honored this function with his inspirational thoughts. I would like to thank our chairperson, Mrs. Regina J. Murali, and our director, Mr. Murali S., and our principal, Dr. Mrs. Lavanya L., all department HODs, staff members, student coordinators, and last but not least, our students for making this event as a grand success. Once again, I thank you all. Thank you.
Thank you, Lalita.
Students, if you have any questions, you can raise.
Thank you, students. If you have any doubts regarding the session, you can ask and clarify your doubts now.
Or you can give your feedback too.
For questions, I can just tell simply whether you understood whatever I spoke. If you at least tell that, I'll be okay, fine. At least I'll be happy. That's fine, ma'am. I guess no questions from them. You can end the session then.
So wonderful session, sir. Thank you so much.
Yes, ma'am.
Very basic thing, and how they can have the idea while starting their startup. Everything is too good. You have given the fundamentals with all excellent examples, sir.
Yes,
Thank you so much, sir.
Yeah. Sure. Thank you again.
Okay, ma, photo session, MC.
Students can turn on your camera.
So, ma'am, we'll end the session.
Yes, sir. Thank you, sir. Thank you so much.
Thank you. Thank you.
Thank you so much, sir. Sorry for the delay, sir. I'll take it back.
Yes.
Thank you, sir. You're welcome. Okay, ma'am, post the feedback.
Students, check your. There is a feedback cost. And also posted in the another group.
Okay, ma'am, let's wind up. Thank you.
Okay.